Employers often ask us to include non-compete or non-solicitation provisions in their employment agreements. And California, and so if you're not aware, non-compete means that after the employee leaves, he or she can't work for a competitor or in a similar industry for a certain number of years or within a certain geographic range. And non-solicit means they can't poach other employees or get the employees from the place that they left to go work with them. And California is, like it is in a lot of things, it's kind of an outlier in this area. It has the most protective provisions for employees and for people's right to work. So most states, or I think most states, are probably allow reasonable restrictions, which might be, you can't work within 10 miles of the employer for a couple of years after you leave in the same industry. But California prohibits any kind of clauses like that. They're really protective of people's right to work in their chosen profession. So we get employers asking us to include this a lot, and it's not a good idea. There are a few small exceptions to this law, this prohibition, but in general, it's not a good idea. It could invalidate an entire contract. But we have people saying, say that they can't work in California, in the same industry in California for 5 years after. That's not going to fly in this state. Sometimes you can kind of tie it to trade secrets. You can prevent them from soliciting employees with trade secrets. That's one possibility. We'll get to that slide next. But yeah, California really protects employees' right to work.